Hi, I'm Gary Humble, and we're having a conversation about the Constitution. And today, in particular, I want to talk about our emergency powers statute and how that lines up, or maybe not so much, with the Tennessee Constitution. In our Tennessee Code 58-2107 is where it defines the governor's powers, his authority under our emergency powers, which we're currently under COVID-19 restrictions operating in the state of Tennessee. There's a few odd things about that statute that really, if you're a person who really understands liberty and consent of government, they really don't quite line up, even if you don't know anything about our Constitution. One of those things is that the governor has the power to unilaterally declare a state of emergency and enact his emergency powers, which give him sort of super constitutional powers in our state to delegate authority, to make law, to do all sorts of things that otherwise he wouldn't be able to do. Not only does he have the unilateral authority to declare that state of emergency, but the current statute gives him the ability to renew those powers every 60 days. The statute says they expire in 60 days, yet the governor also has the sole authority, according to the statute, to renew those powers. And there's no limitations into how often he can actually renew those powers, which means essentially a governor can sort of become a king, a guy who can give himself powers, continue to renew those powers on his own, and give himself the ability to delegate authority to whoever he wants and to make the laws that he wants. Why? Oh, to keep us safe. Well, most people have a problem with that, but we don't really understand why. And most people say, well, that's unconstitutional, but we can't really communicate why. So I want to try to sort of help with that. So in particular, part of how we derive our what we call our policing powers in the state of Tennessee, really in every state, starts out from the 10th Amendment of the U.S. Constitution, which says this: the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. Or to the people is a really important part of the 10th Amendment, and most people don't really talk about whenever we quote the 10th Amendment. But that is the amendment in the U.S. Constitution where we derive the state's ability to assume extra powers. And one of those powers being policing powers, the ability to provide for the common good and provide for the safety and the benefit and the liberty for everyone, especially even in times of an emergency, which a state needs to do that. There's no question. The problem is that oftentimes it's interpreted that a state has the ability to enact those emergency powers even to be super or extra constitutional. In other words, that during an emergency power season, citizens should expect that we must give up some of our constitutional rights in order for those emergency powers to exist. And while maybe some states can sort of extrapolate that by their own constitution, certainly not so, as we will see in our Tennessee Constitution, which does a fantastic job of securing the rights of the citizens of our state under any situation and circumstance. Let's take a look at this first piece. So in Title 58-107, where we define the powers of the governor under the Emergency Powers Statute, it says this: the governor may issue executive orders, proclamations, and rules, and may amend or rescind them. Here's the key: such executive orders, proclamations, and rules have the force and the effect of law. Now, that's an interesting statement because what the legislature has done with the statute is, quote unquote, essentially give the governor the ability to make laws. And that may seem like for a season to be reasonable, but when you put that up against the Constitution, not so much. Article 3 of the Tennessee Constitution is actually where the governor derives his powers. It's the part of our Constitution that really defines the role of the executive department of our government. And one of the things it says is this: in Section 10, he shall take care that the laws be faithfully executed. Now, that certainly doesn't suggest that the governor has the ability to create laws. Essentially, our Constitution charges the governor with abiding by and faithfully executing the laws that were put in place by the state legislature, by our General Assembly. Also, in Article 3, even when you talk about the governor's veto power, I mean, sort of kind of the ability to get directly involved in law, the governor does have the right to veto a bill, but even that power is able to be checked by the General Assembly. If the governor vetoes a bill and sends it back to the General Assembly, the Assembly has the right to override that veto. So there's checks on the powers between the General Assembly and the governor going both ways. So there's no part of the Constitution in any way, shape, or form that gives the governor any authority at any time whatsoever to make laws. And Article 2 of our Constitution goes even further to say this. In Section 2, no person or persons belonging to one of these departments shall exercise any of the powers properly belonging to either of the others. In other words, the legislature at no time can do the job the Constitution ascribes to the governor, to the executive department of our government. And at no time can the governor execute the duties that the Constitution has specifically given to the legislature. Not to mention, we've not even talked about the third branch of our government, the judiciary, which also has its own roles and its own place of competency within our government. So Article 2 clearly states that in defining everyone's role in each branch of government, those things can't mix. One can't do the other. So even by that mode alone, the emergency powers statute is clearly unconstitutional because it creates a situation where all of a sudden our executive leader, our governor, really becomes the entire legislature. And the Constitution simply gives him no authority to do that. There's another problem with these executive powers, and it's where it says this: the governor is authorized to delegate such powers as the governor may deem prudent. Now, that's a really wide and varied statement to simply say that the government can delegate powers as he deems prudent. Well, delegate to who and at what time? The statute really doesn't say to who or how to go about that delegation of powers. And what's happened here in 2020, most notably, is that Governor Lee has delegated to boards of health, but also to county executives, which is the crucial piece I want to address. He made an executive order giving county mayors the ability to create mask mandates within their own counties by his authority. And he used the delegated authority given to him by the statute. The problem is quite unconstitutional. In fact, in Article 7, Section 1, the Constitution says this: the qualified voters of each county shall elect the terms of 4 years, a legislative body, a county executive, a sheriff, a trustee, a register, a county clerk, and an assessor of property. Their qualifications and duties shall be prescribed by the General Assembly. So in Article 7, the Constitution clearly gives citizens of each county the ability by majority vote to elect their own county mayors and sheriff and trustees and all the county offices that we have today. But one specific thing that the Constitution mentions is that those powers of those county officials can only be prescribed by the General Assembly, by our legislature. And again, the Constitution makes no room, no special occasion by which all of a sudden those duties or powers are prescribed by the governor or by the executive department of our state. It makes no room for that. So again, it's another way that this statute that we have in Title 58 is completely unconstitutional. You just won't find a part of our Constitution that supports giving the governor these extraordinary powers. And I think really, here's the last major problem with how our emergency powers statute stacks up to our Tennessee Constitution. A lot of people will say, well, states under this policing power have the right to at times sort of overshadow or remove some of these constitutional protections, which on its face to me is an absurd statement Because if that's possible, well, then we don't actually have a constitution, do we? The Constitution, then, therefore, is not actually the supreme law of the land, then is it? If it can be overridden in some special circumstance. And really, that sort of comes, I think that thinking comes from the doctrine of the necessary and proper clause that we find in our US Constitution, which sort of allows Congress to kind of stretch the powers and authority that it's been expressly given. Here's a great example. Let me give you a really stupid, silly example. Let's say that the Constitution gave our government the duty to mow our grass. Okay, so the government's got to mow your grass. Well, in order to fulfill that duty, there's some things that are necessary and proper that the government would need the authority to do that statement didn't expressly give it. For example, government would have to buy a lawnmower. The government would need to be able to buy gas and put gas in the lawnmower, put oil in the lawnmower, maintain the lawnmower, perhaps sharpen the blade every now and then. So you see, there's a lot of extra little things that Congress would have to be allowed to do in terms of carrying out the duty of mowing your grass. We sort of take that doctrine into policing powers and emergency powers and sort of say, well, since we have a statute that gives the governor the authority to keep us safe, well, there are extraordinary things that he might need to do to actually accomplish the goal of keeping us safe, even though they might sort of kind of be unconstitutional. And that's the problem that we find ourselves in. So how do we combat that sentiment? Fortunately for us here in Tennessee, we have a great section of our Constitution which says this. Article 11, Section 16 says the Declaration of Rights hereto prefixed is declared to be part of the Constitution of the state and shall never be violated on any pretense whatever. And to guard against transgression of the high powers we have delegated, we declare that everything in the Bill of Rights contained is accepted out of the general powers of the government and shall forever remain inviolate. What an incredible statement. In other words, just to be silly, if the zombie apocalypse was upon us, and dead people were walking around trying to eat your brain, the government's ability to keep you safe still does not supersede our Tennessee state constitution. At all times, at any time, every time, our executives, our legislature, and our judiciary can only do the things that we, the people, have given them, have consented to give them the authority to do in our Tennessee state constitution. And I love the statement here in section 16. It says, and we declare everything in the Bill of Rights contained, quote, accepted out of the general powers of the government. In other words, in Article 1 in our Declaration of Rights of the Tennessee State Constitution, the government has no authority and no power to remove those rights from the people of this state. They have been accepted out of the general powers of the government. We'll get into more as to why that's important in some subsequent videos recording business closures, the delegation of non-essential and essential workers, and mask mandates. But in particular, I want to put forward the point in closing that our Constitution simply does not allow for an emergency power statute that allows any part of our government to supersede the authority of which it's been given. In other words, the governor does not have the authority to make law or to make anything with the force of law. No matter if the legislature passed such a law, it's simply unconstitutional. Also, the governor does not have the constitutional authority to delegate any powers whatsoever to county mayors to issue any kind of mandate, because those powers can only be prescribed by the General Assembly. I hope you're paying attention. I hope you follow on with some of these other videos. It is so critically important that we understand our rights and we understand the place that our Constitution holds in how our government works in Tennessee, and it's time for us to stand.